Hey, everybody, this is Peter Hafner, certified financial planner, certified financial fiduciary, and we're welcoming back Dawn Myszka. And Dawn Myszka's with PB Elder Care. And hi, Dawn. It's nice to see you again.
Hi, Peter. Same to you.
So, Dawn, I had a situation come up where I've been doing this a long time, and I still get surprised by things that happen that have to do with the law. And this is with a client. She's a nice lady, but she was kind of ornery too, and she definitely had strong opinions about things, which made her even more endearing, maybe. But she was very particular about how she wanted her beneficiary set up.
Okay.
And me as an advisor, I was just trying to fulfill her wishes more than anything, which we did. We set everything up exactly the way she wanted it. And I know you've had clients like this too. They have different ideas, then they change them later. Whereas most people, I think, in my experience, most people, when they assign beneficiaries, husbands and wives are equal, 100% beneficiaries, and kids are equal contingent. I mean, in most
And
cases, that's the way it works, right?
yeah, the standard. Yep. Yep.
Yeah. When you get to second marriages, sometimes it takes on a little different twist, but mostly that's the way it works. Now, this particular lady, she was no longer married anymore. And what she did is she had two brothers who she named as beneficiaries. And I'm not even sure I really knew how many kids she had, but she named a daughter as a co-beneficiary on one account with a brother, and then the other brother as a full beneficiary on a different account, which is really unusual. And like I say, I didn't think much about it. My job is to make sure things are going to go the way the client wants them to go. That is my job. And
Exactly.
and
Yep.
to give advice and ask and answer questions, which I did. But she's since passed, and then it's a different job I've got. Now I've got to contact beneficiaries and talk about things. It's also interesting because I can't talk to beneficiaries about the whole. I can only talk to them about what they are
What
receiving.
they're receiving, right? What they're
Yeah.
entitled to, right? Yep.
And in this case, the daughter, someone else was the executor. Now, the executor, because of the will, has a much greater scope of what they can see. They can basically see the big picture, and they can understand how things are going with assigned beneficiaries and other accounts. They can infer this. But like the daughter, I'm letting her know, and she says, "Oh, do you want me to get in touch with my sister?" And her sister had not been named as a beneficiary anywhere on anything that this woman had with me. So I couldn't tell her, "I'm sorry, but your mom didn't name your sister as a beneficiary." I was in an awkward position of just saying, all I can talk to you about is what you are receiving.
Yep.
Um, Boy, that was a strange situation to be in. Um, and it just made me think, when people are assigning beneficiaries in these unique ways in the future, I'm going to have a greater conversation with them about this, I think, than I've had before. Um, in part because it's an awkward situation for you or me to be in later in life. And then I'll let you talk a little bit. And I suspect that things like this, especially because I am so limited in what I can say to people, it can lead to the people who are not receiving things to start to wonder what's going on. And then it leads to trouble and it leads to infighting. And I know it's like we can have great relationships with the parents, with our clients, but then when it goes to the next generation, oftentimes those people can be really disenchanted and unhappy. And then this fighting starts because people feel like they're not getting what they're supposed to get.
Yep.
So tell me more about this. Tell me what you do to avoid um, these sorts of contested situations. What are best practices? What can the people who are paying attention today, what should they take away from what we're talking about right now?
So, Peter, what you've just experienced and what you've explained, it's not uncommon when doing estate planning, doing what I do, doing what you do. It's a very sensitive topic, right? And it's not uncommon for family conflicts to happen at a later time. And that
Yep.
later time is always when the loved one passes away. And at that time is when beneficiaries are made aware of what they received. And then you may get family members who are still waiting and waiting for that word, waiting for that letter, right? So in a situation like that, when I meet with clients, we understand the sensitivity of it. If there's questions or issues where the client wants to disinherit somebody for whatever reason, we really delve into that because we need to make sure the person understands why they're doing that and what the potential consequences could be. Just like your own profession, Peter, my profession, we will do what a client wants us to do. My job is to make sure that the client is informed with their decision. We don't, you know, tell them otherwise, we don't make the decisions for them, but we give them the pros and cons for disinheriting one child or benefiting another child more than their other children. It is a fine line, a very fine line. And some of my clients asked, well, should I sit down with my kids and talk about what we're doing? I'm going to say with anything, it depends.
Hmm.
Okay. Because when the parent sits down with the children, and are you going to be able to get the children all together, face to face meeting without significant others involved? Okay. Are you going to be able to do that? And then sometimes what my experience is that the children may appear to think that they have to make the decision. And then what they would want, they transpose it to the parent. And is it really what the parent was thinking, what the parent's plan was going to be? So it's one of those fine lines. And I think you handled your situation perfectly. Perfectly. Sometimes family members, if they want to sit down, and you have a client who is a very strong person and they're going to make their decision and they're going to tell their children, well, here's why I disinherited you, or here's why you're getting less than your sibling. And if the children accept it, that's fine. But if the children don't accept it, then when the client passes away, this is where my job comes in to make sure that again that the client made that decision, full knowledge, full information, that they weren't being influenced by anybody else, any of the other children, in making their decisions one way or the other, be it as a beneficiary under a last will and testament, as a beneficiary under a life insurance policy or any investment accounts, or whether they're choosing somebody as power of attorney. It makes no difference. And this is something that clients need to also understand. If you're designating your child or a child on your bank account as a trust, or excuse me, as a beneficiary on your bank account, right? Some financial institutions, what I've been seeing is if you have more than one child, they will only allow you to set up that bank account transferred upon death to that one child. If you have three children, the other two children are kind of going to be, out of luck with that with that bank account. Mom has a bank.
That's what banks are doing?
Yeah, some banks, some financial institutions are only allowing one child to be designated as the transfer on death
Kidding.
beneficiary.
Why would they do that?
I have no idea.
That's just
And this is just what I have clients reporting back to me when I
yeah,
tell them to go and do this, and they're reporting back to me. So then we have to rethink everything. If the
right,
client wants to treat the children equally, then now we're, proposing perhaps a trust. So then that way all of the children are treated equally upon your death with
right.
whatever assets that you have.
Okay. Hey, let me pivot a little bit. You brought up trust, and I had a situation with another client who had a special needs child, and I asked her if she had a special needs trust. And what she said to me is, we have it built into our will. So when we die, a trust springs up. And as I was thinking about that, not being an attorney, but someone who's assigning beneficiaries to various accounts, there's no trust. You don't want to name the third child, the special needs child, as a beneficiary. Usually they've got a trust, but there was like no good way to make this work, because if you, in place of the special needs child, you name the estate, then the money will get split again between the other children. And it seemed like a really bad way to go. And this woman, very nice woman, but she said to me something like, "You don't know very much about this, do you, Peter? This is the way most people do this." And then as I'm thinking about it, I'm like, no, that can't possibly be right, because it's really important that the money doesn't go directly to the child. And if the money goes through the estate, then it's a 5 year time frame to get the money out as well, instead of 10 if it's coming out of IRAs. So it's much better to have the special needs trust set up to just receive the assets, and set it up before you die, instead of it springing into life after you die. Does it work to have it spring up if there's multiple children and they want all the children to get an equal amount?
Yeah, so this is where, again, as a lawyer, I love saying always, it depends, depends on, the client's assets. Do the parents own their home? If do they have investment accounts? What assets do they have?
Hang on, let's keep it real simple. Let's say they got a couple different IRAs, they got a house, and that's it. Okay. They got 3 kids. They want the money to go to the 3 kids equally, but one is special needs. I think it's really important to have the special needs trust set up and named as beneficiary on those IRAs.
They
In that
right, they could,
case,
yeah, they could do that. If they didn't do that, but they named
okay,
if everything then went through probate, then it would siphon down where the special needs child, under the parent's will, if there was a special needs trust set up under the will, then that money, would be siphoned off to them under that special type of supplemental needs trust under the will. But the problem is, you got probate costs, you got delays. Now you have the lengthy administration of that supplemental needs trust, with a trustee to be appointed for the lifetime of that special needs child. It it can get complicated, and just, continue on, which some clients may feel this will never end. When is this going to end? We don't want this, for like 10, 15, 20 years. And that's where sitting down with you, Peter, sitting down with an attorney, reviewing all of that, seeing what goes where, the best way to protect the assets from whatever the special need child needs, but to carry out the client's wishes.
so you said a lot of stuff, but in my simple example, it really makes a lot of sense for them to have the special needs trust set up prior to death, so that the money gets split 3 ways. All 3 kids get what they're entitled to, and the special needs child doesn't lose their benefits.
Right.
That's a good way to go. Okay.
Yeah. Yeah.
Well, and actually, as we were having these, as we started talking about setting up that's where I started to realize I put it all together with that particular client. They're like, "Oh yeah, that does make sense." I'm like, "Okay, good." Um,
I mean, and in that case, if there is an IRA, and depending on, what the value of that IRA is, and you have a house, the house is equivalent to the value of the IRA, you may just want to name the non-special needs children the beneficiaries of the IRA,
Right.
and then then there's something you can do with the house and putting that possibly under the supplemental needs
Yeah.
trust.
So you're doing a high level of planning there, though. Whereas
Yeah.
mm, if they're working with an attorney, they're going to think of that. But if they're, but anyway, yeah, that folks, this stuff gets really complicated quickly. There's many unintended. It's really easy to miss something and have an unintended negative consequence. So it's really good to talk things through with attorneys to make sure this is set up right. Now, Don, another thing that's been coming up that I'm having trouble, and we've talked about this a number of times, but people are always afraid about the nursing home or the state getting all their assets. If they go into the home, then the state's going to take all their money away. And let me just say this first. That's not a fair way to look at it, in my opinion, because if someone's in the home, they're getting a lot of services and it costs a lot of money. So it's all, who's going to pay for it, right?
Right.
So
Right.
it's only right that if we wind up in this situation, we got to pay for it. But people are trying to figure out how to protect themselves. And one really good way that I think is important for many, many, many of the people I work with is a personal residence trust or, protecting the house. It's got the 5-year look back. It's pretty easy to set up. You can usually undo it if you're going to move or you want to. That's one good thing that makes a lot of sense for a lot of people. Now, the other thing people ask me about, though, is they ask me about living trusts. And I believe, but I want to make sure with you, a living trust is not going to protect your assets from the nursing home because that is everything is still yours. You still have total control over it. It's an irrevocable trust that's going to put you in the direction of sheltering assets after 5 years go by. Am I on the
Right.
right track with this?
Right. An irrevocable trust is still considered a living trust because it's something that you've created during your lifetime. So the irrevocable trust is the type of trust that would protect and shelter your assets if you did need to apply for Medicaid. A regular revocable living trust, that's you still maintain the control and the ownership to do what you want with that, and that's not really going to help.
Yeah, thank you. I did not know a living trust could be applied to both irrevocable and revocable. That's
Yeah.
where I was confused. I'm used to seeing people having revocable living trusts, especially before TODs and PODs became prominent. Now I see them rarely. Usually they're for people set them up many years ago, or they're for people who have like assets like airplanes or car collections, not like bank accounts where you go sign a piece of paper.
Yeah.
So again, to round this out, I'm using the wrong terminology. If you want to try to shelter assets from the home, there's a 5-year look back and it's an irrevocable trust you need to put your assets into. Now, the revocable trust, that's no problem. It's on your social security number. You still have access. You're in control. You're the boss. You get to decide what you do or don't do, what comes in and what goes out. But if you put it into an irrevocable trust, you're going to have a tax ID number and someone's going to be the trustee. Can you be the trustee on your own irrevocable trust?
No, because with the idea is because you're creating that trust to give up the right that you own of the assets that you put in the trust. So you cannot be the trustee. Because if you're the trustee, you then have the ownership and the oversight of what you put in it, but you cannot be the trustee.
Can't be both. It
Can't be
cannot
both.
be both.
No.
So that's the whole idea. If you want to shelter your money from the home, you can give it away to charity and now it's not yours anymore after 5 years go by, or you can sort of give it away to the irrevocable trust and someone else is in charge of it now, and you have written the rules for how money is distributed and how it gets treated. But
I liked how you said that, Peter, that you've written the rules because
yeah,
when creating the trust, yes, you are the one that are writing up the rules as to how, when you pass away, if you put your house in the trust, house is sold, how that asset is then going to be distributed. You create that. And even though it's irrevocable, remember, you could still change the rules after you've created that irrevocable trust. You can still change the rules as to who gets what under your trust after you've died.
I didn't know that. Okay.
Uh-huh.
So even though, so as the, what are you called, the person who puts the assets into the trust?
You're
What's
called the grantor.
the grantor? That's
Mm-hmm.
right. So the grantor writes the rules, and they can change the rules as
Yep.
time goes by.
Yep. The only thing that the grantor cannot do in changing the rules, the grantor cannot add themselves to be the beneficiary of the trust or the trustee. But they could keep changing the rules and say, no, I have 3 kids. I've decided I like one child better than the other now. So they're going to get 50% and the other two are going to get 25% each. And they can keep changing it. It's called a power of appointment under your irrevocable trust.
Yeah. Okay. Now, if I am setting up an irrevocable trust and I cannot be the trustee who's managing the assets, who can be the trustee?
Anybody that you trust,
So could
family
my wife
member.
be the trustee?
If your wife is also the grantor, then she cannot be the trustee. So you can name your children as the trustee. You can
Okay.
name a sibling as a trustee. Anybody.
Okay.
Mhm.
So this really is, and you write the rules so you can write it. Are like when you have some kind of trust, like charitable remainder trusts, I think there's rules about how much income can go out of those. Maybe less than 5% or less. Is that?
Right. Those rules are legal rules that you really can't change.
Yeah,
But
that's what
the
I
the
mean.
final, yeah, the final distribution rules, you can keep changing those.
Okay. Okay. So for if I'm just setting up an irrevocable trust because I'm trying to shelter assets from the home, I can set it up so that I'm allowed to take out 50%. If the grantor needs the money, the trustee is allowed to transfer as much as whatever percent. Now, is there any governing rules on that?
You can't really set it up like that.
Okay.
If the grantor needed money out of the irrevocable trust, the trustee would either have to do one of two things. Well, the grantor would have to revoke that portion of the trust for that amount of money so that that money gets paid to the grantor, or the trustee can withdraw that money, put that money in the trustee's left pocket, write a check from the trustee's left pocket back to the grantor.
All right. So the bigger picture is if I'm the grantor, I cannot be a beneficiary of the trust. I cannot receive benefit from the trust.
Right. You can't go to the trustee and say, "Hey, I need, 10 grand because I want to go on a trip." Now, if you're investing money, you have a brokerage account, the grantor receives the income and the dividends generated from that cash. That's really the
Okay. So
only thing that they receive.
that's more the lines I was going down. Let's say we put $1 million into it, and it could generate maybe $100,000 a year in income.
Uh-huh.
So
Mhm.
could the grantor receive that income from the trust?
Exactly. Yep,
Okay.
exactly.
And then if they were going into a Medicaid type situation, it's the income that's going to be attachable as per the statutory limits.
Exactly. Not the principal of that $1 million account.
If
That's
five
correct.
years have gone by, the assets are free and clear.
Yep,
However, the trust says they're going to be distributed, that's where they're going.
that's correct. Yep.
That's interesting.
And since it's a new year, Peter, it
Yeah.
is
Uh-huh.
still It is still the 5-year look back. That has not changed.
Is there any talk of it changing?
No, not that I'm hearing.
Except
No.
from our clients every once in
Yeah.
a while. I think it's 7.
Yeah. I don't know where that comes from.
It's in the air. I don't know. Sometimes they start to convince me I'm wrong, but it's 5 years. I'm glad you're saying that. All right, we're like 25 minutes in. That's probably enough for today. Um, Let me say this to everyone out there. Hey, if you've got questions you want us to talk about, let us know. We're always looking for ideas. You can send an email to service@hafnerfinancial.com or call the office. And with that, Dawn, thanks for coming. We're gonna say goodbye. Hope you have a great weekend, and it was really nice seeing you again.
You too, Peter. Take care.
All right, bye bye.